Earlier today at 9:33 a.m. Eastern Time, my office received formal notice that Melania Trump's attorneys had rejected a proposed cooperation agreement with federal prosecutors. The terms of that agreement were explicit and standard. If Mrs. Trump agreed to provide truthful testimony regarding 3 specific financial transactions she personally witnessed, the government would recommend a substantial reduction in Ivanka Trump's potential sentence in the ongoing federal fraud prosecution. Melania Trump declined the offer in full. 17 minutes after that refusal was received, my office began receiving evidence. Not speculation, not political commentary. Evidence, a sworn witness statement from a Secret Service agent, contemporaneous text messages between members of the Trump family, and a public social media post that was quickly deleted but preserved through screenshots. Together, these materials document the defendant's immediate reaction after being informed that Melania Trump would not assist the government in keeping his daughter out of federal prison. This should not be dismissed as routine family conflict. From a legal standpoint, what occurred this morning is significant. Federal prosecutors extended a cooperation offer to Melania Trump that followed well-established prosecutorial practice. The proposal was simple. Testify truthfully about 3 financial transactions you personally observed, and the government will recommend a downward departure in Ivanka Trump's sentencing. Melania Trump refused. As a result, Ivanka Trump now faces an estimated sentencing range of 11 to 19 years in federal prison on charges of bank fraud, tax fraud, and conspiracy. Had Melania Trump cooperated, that exposure could have been reduced to approximately 6 to 10 years. That reduction is not theoretical. It represents the difference between Ivanka Trump's youngest child finishing elementary school while their mother is incarcerated versus finishing high school before her release. Based on evidence obtained by my office this morning, the defendant reacted to this refusal with anger, threats, and efforts to pressure other family members, conduct that, under federal law, is routinely described as consciousness of guilt. Let me be clear about Melania Trump's status in this investigation. She was not charged. She was not a target. She was a witness with direct, first-hand knowledge of the financial conduct underlying Ivanka Trump's case. On April 15, 2024, I authorized the first subpoena for Melania Trump's financial records after her name appeared as a signatory on accounts associated with fraudulent loan applications tied to the Trump organization. Those records showed her signature connected to 17 separate transactions between 2018 and 2022. By July 2024, my office had interviewed Melania Trump twice under subpoena. During those sessions, she acknowledged being present at meetings involving the defendant and Ivanka Trump, where loan documents were discussed and altered. She heard instructions. She observed documents. She participated in communications relevant to offshore financial structures. Critically, those interviews confirmed that she possessed first-hand knowledge of conduct central to the charged offenses. On October 3, 2024, Ivanka Trump was formally charged with 3 counts of bank fraud, 2 counts of tax fraud, and 1 count of conspiracy. The case was already strong, supported by documentary evidence and cooperating accountant testimony. However, Melania Trump's corroboration would have made the case nearly unassailable. Accordingly, on December 9, 2024, my office sent a formal proffer letter to her attorneys outlining precise cooperation terms. Her legal team requested and received 2 deadline extensions. Both the January and February deadlines passed. Her attorneys cited concerns about marital privilege, concerns that do not apply to business transactions conducted in the presence of third parties. At 9:33 a.m. this morning, her attorneys submitted a formal refusal. The letter stated in full substance that after careful consideration, Mrs. Trump declined the government's cooperation offer and would not testify in United States versus Ivanka Trump. There was no counterproposal, no legal argument, simply a refusal. Spousal privilege protects private marital communications about personal matters. It does not shield business meetings, financial transactions, or discussions conducted in front of accountants, executives, or other third parties. This refusal was not compelled by law. It was a choice. That choice mattered because of what Melania Trump could have testified to. First, a May 17, 2019 meeting at the Mar-a-Lago executive offices involving the defendant, Ivanka Trump, Melania Trump, and 2 Trump Organization accountants. The meeting concerned a $47 million loan application submitted to Deutsche Bank. I possess emails confirming the meeting, and an accountant has testified that the defendant instructed Ivanka to inflate asset valuations using outdated appraisals. Melania Trump was seated at that table. Her testimony would have corroborated that instruction. Second, a series of text message exchanges between Melania and Ivanka Trump in August 2020 during an IRS audit of Trump Organization tax filings. In these messages, Ivanka sought guidance on handling asset disclosures. Melania's responses demonstrate knowledge of offshore account structures, including a message referencing the use of a Cyprus structure to conceal beneficial ownership. Her testimony would have explained what that term meant, what had been discussed with the defendant, and how those structures were used. Third, Melania Trump had firsthand knowledge of offshore accounts controlled by Ivanka Trump. Bank records list Melania as an authorized user on accounts in Cyprus and the Cayman Islands that received approximately $18.4 million between 2018 and 2022. Her testimony could have clarified the source of those funds and Ivanka's control over the accounts. Corroboration is powerful. I already have emails, bank records, text messages, and accountant testimony. When a family member who was physically present confirms what those documents show, it eliminates reasonable doubt. Business transactions do not receive family immunity under federal law. Now consider the defendant's reaction to Melania Trump's refusal. At approximately 10:15 a.m., a Secret Service agent assigned to the defendant submitted a voluntary sworn statement describing a phone call overheard between the defendant and his lead attorney. The agent heard the defendant shouting accusations of betrayal. After the call ended, the defendant allegedly threw his phone against a wall. Shortly thereafter, text messages were sent to another family member urging them to pressure Melania, warning of consequences. Minutes later, a public post threatening disloyal wives was published and deleted within 17 minutes. Screenshots were preserved. In court, this sequence, rage, intimidation, and attempted witness influence, is classic evidence of consciousness of guilt. If Melania Trump's testimony were irrelevant or false, there would be no reason for this response. I have prosecuted organized crime cases where similar conduct was introduced as evidence, and juries understand it. Without cooperation, Ivanka Trump's sentencing exposure remains severe. Under federal guidelines, the combined ranges for her offenses result in an estimated 11 to 19 years of imprisonment, with no parole and a requirement that at least 85% of the sentence be served. Absent mitigation, my office will recommend a sentence at the high end of that range. This case also fits a broader pattern. Ivanka Trump is the third Trump family member charged in financial crimes arising from Trump Organization conduct. Each case involves falsified documents, offshore accounts, concealed ownership, and coordinated family participation. In legal terms, this reflects a continuing criminal enterprise. I have prosecuted similar structures before. The pattern is clear. Trial is scheduled to begin June 9th, 2026. The evidence will include bank records, emails, wire transfers, text messages, and testimony from cooperating witnesses. Melania Trump's testimony would have strengthened the case, but it is not required. Documents speak clearly, and juries understand financial trails. The process now moves forward. No one is above the law, not the defendant, not his sons, not his daughter. Trial begins in 124 days. Hello, ladies, how are you?